Good afternoon, and thank you everyone for joining us for today's webinar, in which we'll be providing an update on recent developments in the field of public procurement. My name is Chris Tayton, and I'm joined by my colleague Emma Butcher. For those of you who have listened to our webinars previously, we also broadcast a longer webinar as part of our Need to Know series, which provides a detailed guide to all aspects of bringing a procurement challenge. That webinar will be broadcast later this year in the autumn. Today, we will just be looking at recent developments. I say just, but last week saw the UK serving notice of its intention to leave the EU, and also the government's announcement of one of the largest compensation payments in procurement history, so we have quite a lot to cover. As usual, we will be primarily looking at these developments through the eyes of a business who bids for public contracts and may have concerns about the way a public tender has been run or a contract has been awarded. However, we hope what we will say will be of interest to everyone involved in public procurement, whatever their role.
The key piece of legislation that we will be talking about today is the Public Contracts Regulations 2015. Most of the tenders that you participate in or run will be governed by those regulations, and they apply in England, Wales and Northern Ireland. Some tenders are governed by other associated pieces of legislation, which I have listed on the slides there. Although we will be largely talking about the public contracts regulations, many of the same principles also apply to the other sorts of regulations. So just by way of reminder, the sorts of tenders which are covered by the regulations are those which are run by public bodies and which are above the financial thresholds, which again I've set out on the slides. There are some exceptions. Some specific types of contract are subject to what's called the light touch regime, and some basic requirements also still apply to below threshold contracts, but not the full regime. So when can a bidder bring a challenge? Well, there are three key circumstances. The first is where a public body has not complied with a provision of the regulations. And the key obligations, which are set out in Regulation 18, are to treat bidders equally and without discrimination, and to act in a transparent and proportionate manner. The second key circumstance is where a public body makes a decision which is based on the wrong facts, and the third is where a public body has exceeded its discretion or made a manifest error. So how does all of that apply in practice? Well, we're going to take you through some examples and some recent cases which demonstrate these principles. The first key category of challenge is challenges to tender design, and these tend to be based on things like publishing or typographical errors, confusing or ambiguous language, requirements that cannot be met, for example because they refer to a product or a standard which no longer exists, or requirements which favour one bidder over another, for example because they name a particular product in the specification which is made by a particular bidder. There's always an issue with timing when you bring a challenge to tender design, because the limitation period for bringing challenges under the regulations is 30 days, and this can be extended to a maximum of 3 months, but only in very limited circumstances. So due to the length of time that most procurements take, it's usually the case that that 30-day period will expire before you've even submitted your bid, let alone whether you know you've won or not. So generally a bidder does not have the possibility of waiting and seeing whether they've won before deciding to bring a challenge to tender design. How will the court manage a claim if the procurement's still ongoing? Well, there's been a useful recent case on this called Joseph Gleave and the Secretary of State for Defence. And that says that essentially there are two options for the court. First of all, it could stay the proceedings until the outcome of the procurement is known. And that's what the court ultimately decided to do in Joseph Gleave, because they said if the claimant's bid had won, then they wouldn't have suffered any loss. The second option is, in an appropriate case, the court can order an expedited trial. Normally cases take many months to get to trial, although procurement claims do tend to be quicker than many other types of claim. But if it's possible to do so, then the court could order a trial to take place within just 1 or 2 months, which could be before the contract is due to be awarded. In Joseph Gleave, though, the court decided that it could not order an expedited trial because very complex technical evidence was required due to the nature of the challenge that had been brought. In a simpler case, though, that might be possible. There is a third possibility for the court. In an appropriate case, they might also agree to grant an injunction halting the procurement. but the bidder would have to specifically apply for this, and the test for granting an injunction is quite a high one. The next category of challenge is challenges brought to the tender evaluation. And examples of this would be things like marking errors, such as incorrect adding up or weighting, awarding marks on the basis of incorrect facts, for example misreading or misunderstanding an answer, or perhaps mistakenly believing that a bidder has not supplied a mandatory document. What if you actually have omitted a document? Or you've made a mistake in one of your documents? Or you're the public body and the bidder uploads a document late or has missed a vital one? Can you ask for it to be supplied after the deadline? And will the bidder have grounds for a challenge if you don't? The court considered these issues recently in the case of Denmaster Demolition and Renfrewshire, which is a Scottish case. And what happened here is that the bidder had accidentally missed a key document, and then they argued that the authority should have given them the chance to correct their bid by uploading it after the deadline. Well, the court disagreed, and they said actually, on the contrary, allowing a late submission of the document could have been a breach of the regulations and could have given rise to a challenge from the other bidders who did submit all their documents on time. The only circumstances in which things can be submitted after the deadline are if the bid contains an ambiguity and the authority is simply seeking clarification on that rather than there being a complete failure to submit a document, or the other circumstance is if a document is requested after the deadline but it can be objectively shown that it was produced before the deadline and the tender documents did not contain a specific requirement that the tender would be rejected if the omitted documents were not provided. In the case of Denmaster, the evidence showed that actually the bidder hadn't prepared the document that it wanted to submit late until after the deadline, so it wasn't allowed in that case. The next sort of challenge that you might want to bring is the challenge to tender evaluation, where the evaluator has some kind of discretion. And these are generally the hardest kinds of challenge to bring because the courts will only interfere with the exercise of an evaluator's discretion where there has been a manifest error. Evaluators are allowed a margin of appreciation, and generally the court's role is not to remark the tender, although it will do so in cases of serious deficiencies in the evaluation. You could also have a challenge if you could show that in exercising their discretion, the evaluators have breached one of the procurement principles of equality, non-discrimination and transparency.
We now look at last week's announcement to Parliament by Greg Clark, the Energy Secretary, that the Nuclear Decommissioning Authority, the NDA, had settled its long-running dispute with the joint venture between Energy Solutions and Bechtel. This dispute has captivated the legal press since 2014, when the NDA announced the award of a £6.4 billion contract to a JV between Cavendish Nuclear and the US company Fleur. Days later, the NDA received a legal challenge from the unsuccessful bidders seeking £100 million in compensation. The contract had been for the decommissioning of the UK's fleet of 12 first-generation Magnox nuclear reactors, including Sizewell in Suffolk and Hinkley Point in Somerset, and was expected to last for 14 years. On any view, this was a huge public tender. The losing bidder claimed to have spent £10 million participating in the tender alone. The size of the tender was very clearly reflected in the settlement. The government has agreed to pay just under £100 million of taxpayers' money to the unsuccessful bidder in compensation for not being awarded the contract. The contract that had been awarded in 2014 is now being terminated 9 years early, with the government stressing that they had no complaints about the performance of that contractor. This led to a 3% drop in the share price of the listed company Babcock International, which holds a 65% shareholding in the terminated contract, due to an £800 million drop in revenue. The Energy Secretary also announced an independent inquiry to be headed by Steve Halliday, former Chief Executive of the National Grid, with a mandate to investigate what had gone wrong with the tender and why it had been necessary to terminate early the 15-year contract. This followed very serious criticisms of senior NDA procurement staff by the judge in earlier court hearings. So what went wrong and what legal lessons can be learned from this case? The NDA did not get off to a good start, and a quick understanding of the history of the tender award helps shows why. As this slide shows, Notice of the contract award was given and the 10-day standstill period started running on the 31st of March 2014. To recap, when awarding a contract under the public contract regulations, public bodies are required to allow unsuccessful bidders a period of 10 days, the standstill period, to prevent the contract being awarded by bringing a legal challenge. If a legal challenge is not made in the standstill period, or before the contract is entered, the award may still be challenged within the first 30 days. However, save in very specific circumstances, you are then limited to claiming financial compensation rather than having the contract set aside. Importantly, public bodies are able to extend the standstill period, but only to 30 days. In our experience, extensions are often agreed as generally it's in the interest of both the public body and the unsuccessful bidder to do so, rather than go straight into court proceedings. That is what did not happen in this case, to the NDA's considerable cost. A few days into the standstill period, Energy Solutions raised concerns about the tender award, requested further information from the NDA, and asked them to extend the standstill period so that their concerns could be investigated. One can only assume that the NDA regrets what they did next. On the 1st of April, they refused to extend the standstill period, referring to the considerable costs any delay to the project and would cost the NDA. The standstill period expired on 14 April and the NDA duly entered the contract with a successful bidder the following day. Exactly as they said they would, Energy Solutions then brought a legal challenge against NDA on the 28th of April 2014. By now it was too late to set aside the contract, as this had already been entered, and they were limited to seeking financial compensation, which they valued at £100 million. No doubt matters were much more complicated than this brief summary suggests, but it left the NDA facing a very substantial legal claim. They tried at first to have the whole claim dismissed by arguing that Energy Solutions should be denied any damages because they had broken the chain of causation by not suing NDA during the standstill period. In other words, it was Energy Solutions' fault they had suffered financial loss because they had not issued legal proceedings during the standstill period. This went to the Court of Appeal last year, who firmly rejected this argument and said that there is no obligation to issue legal proceedings during the 10-day standstill period, and that damages will be available provided the claim is started within 30 days. With so much money at stake, the NDA appealed this decision onto the Supreme Court, and this was heard at a 2-day hearing last month. We still do not know the outcome of that decision. It seemed like a weak appeal, so we suspect the government will be unsuccessful, and possibly the parties know the outcome, hence last week's settlement. The clear lesson from this sorry exercise is for public authorities to consider their position very carefully before refusing to extend standstill periods and enter contracts while a genuine complaint is being investigated. This was really just a sideshow. Energy Solutions' main complaint against the NDA was that their evaluation of the bid breached procurement regulations, and that went to trial last year, lasting 23 days and producing a staggering 370-page judgment published last summer. It's far beyond the scope of today's webinar to provide a detailed review of the decision, but needless to say Energy Solutions won, and they won convincingly. This was another example of a case where the court was prepared to investigate in great detail the public body's decision-making process to check it complied with the procurement regulations. To recap, when evaluating a tender submission, a public body is subject to the following duties. Public bodies must not make a manifest error when marking a tender submission, and public bodies must act transparently, treat tenderers equally, and in a non-discriminatory way. Proving a manifest error requires a high level of proof. It includes an error which has obviously been made, a mark which no reasonable evaluator could justify, and a mark which is not capable of rational explanation. It is often easier to prove breach of the procurement principles. If you can show that the evaluator has marked yours and your competitors' submissions in an unequal manner, i.e. awarded comparable answers with different scores, or not transparently, i.e. backdating factors, by taking factors into account which are not disclosed in the tender documents as relevant, you may well have a claim. The NDA were found to have committed multiple breaches of the procurement principles when evaluating the bids in this tender. For example, they had penalised Energy Solutions for omitting information from a tender response, but not applied the same penalty to the winning bidder, who also omitted this information. NDA conceded that some of their scores had to be increased. They had also manipulated the marking to avoid having to disqualify the Cavendish joint venture, the winning bidder, for failing to achieve minimum standards. And they also made a series of manifest errors. The original tender result was that the winning tenderer, the Cavendish JV, had scored 86.48%, and Energy Solutions had scored 85.4%. After the court's intervention, Energy Solutions scores were increased to 91.48%, meaning that they should have won the tender, and thereby entitling them to substantial damages. The lessons learned from this case are that if you have lost a tender, it is critically important that you, firstly, act very quickly. Secondly, work out if you have enough information from the contract award notice to determine if the tender has been properly evaluated. Third, request further information and, if necessary, an extension of the standstill period to complete your investigations. And finally, undertake a detailed analysis of the marking of your tender and the winning bidder's tender. Look in particular for obvious marking errors, cases where the evaluator has not treated you and the winning bidder equally, or where you have marked down for factors not included in the tender documents.
The final category of challenge that might be brought by a bidder is challenges which are brought during the performance of the contract. It's always worth an unsuccessful bidder monitoring the performance of contracts in case potential challenges arise later on. Examples of these might be an unlawful variation of a public contract or the unlawful award of a call-off contract under a framework agreement. There's a recent case which demonstrates this quite neatly. It's called Finfrone and Riggs Politiet. What happened there is that a dispute had arisen between a successful bidder and a public body regarding the performance of a contract. It was a contract for the supply and maintenance of a communication system to be used by the emergency services, and the winning bidder was experiencing very serious operational difficulties in the performance of the contract, which could not really have been foreseen by either party at the bidding stage. So the parties managed to settle their dispute, but part of the agreement that they came to was that the scope of the contract was going to be greatly reduced. It wasn't something that the public body particularly wanted, but it was just necessary as a result of the operational difficulties that they were experiencing. So the public body published a VEET notice, that's a voluntary transparency notice published in the Official Journal of the European Union, and that advised bidders of the variations that had been made to the contract. And one of the unsuccessful bidders from the original tender noticed the VEET notice and brought a challenge on the basis that the varied contract was so different from the original contract that had been tendered for that they said it should have been re-tendered again under the regulations. That's what happened in the Energy Solutions and NDA case that Chris has just talked about. The NDA decided there that the work they actually require to be carried out now is so different from what was originally tendered for that they're obliged to re-tender, and that's why they've ended the existing contract early. So in Finfrone, the court agreed with the unsuccessful bidder and said that the public body had to re-tender. And that was really quite an unfortunate outcome for them, because they had acted very sensibly in resolving their dispute, and they had published a VEET notice in order to comply with their transparency obligations. So it was a shame that they hadn't had any specialist procurement advice on the settlement. So if you're a public body or the successful bidder and you find yourself in a dispute over a regulated contract, definitely bear this in mind and make sure you take specialist procurement advice. And if you're an unsuccessful bidder, make sure you monitor OJU for VEET notices and keep your ear to the ground for any information about how contracts that you've lost are being performed. We're now going to move on to mention one legislative change last year, which was the coming into force of the Modern Slavery Act 2015. We're now starting to see its impact on public procurement. The Act requires large businesses, which are defined as those supplying goods and services with an annual turnover of more than 36 million, to publish a statement each year setting out the action they have taken to ensure that their business and supply chain is free from slavery and trafficking. Much like when the Bribery Act came in 2010, we saw public bodies starting to require evidence of anti-bribery policies from bidders. We're now starting to see the same thing with Modern Slavery Act statements. And the most recent public procurement policy updates and template questionnaires published by the Crown Commercial Service are now containing Modern Slavery Act compliance questions. There are two ways that public bodies can require compliance. First one, and the most common, is to require bidders to confirm that they comply with the requirements of the Act, if applicable, and have the possibility of their bids being excluded if they don't comply, and that's what's included in the Crown Commercial Services standard templates, which I just mentioned. The other way is for the award criteria themselves to include criteria related to the steps which the bidder has taken to ensure the absence of trafficking and forced labour from their supply chain. This might be appropriate in particular industries. If you're a small or medium enterprise with a turnover of less than 36 million, then you're not required yourself to publish a statement, but you are likely to have companies which are required to comply in your supply chain, or you might be part of the supply chain of a company which is required to comply. So depending on the wording of the question, you may still be required to certify for the purpose of a bid that your supply chain is Modern Slavery Act compliant. So far, we've seen companies being a bit slow off the ground to comply with the Act and publish the required statements. It's possible that as a bidder you might have a challenge if the winning bidder is non-compliant but has ticked a box to certify that they are compliant, and therefore they ought to have been excluded. It's quite easy to check if another bidder has complied because the statement should be published on their website quite prominently, so this is something else that as an unsuccessful bidder you might decide to monitor.
And that brings us on to the last topic of today's webinar, Brexit and how it will affect public procurement. Brexit is probably the most talked about issue affecting the UK at the moment. Largely, this is because so much about the UK's future relationship with the EU is unknown. The one thing we can say with certainty is that, as at today's date, procurement law in the UK remains unchanged. The same procurement regulations apply. Businesses established in the UK are able to bid for public contracts in other EU member states and vice versa, and the European Court of Justice remains the final arbiter of disputes under the procurement regulations. The big question is how, if at all, this will be changed by Brexit. As we all know, the process for leaving the EU has just started. Last Wednesday, Theresa May served notice under Article 51 of the Treaty of the European Union 2007. Assuming no extension is agreed, the UK will cease to be a member of the EU on the 29th of March 2019. The treaty obliges the EU now to negotiate an agreement with the UK, setting out the arrangements for its withdrawal, taking account of the framework for its future relationship with the Union. And you'll have seen in the media some of the issues this has thrown up already. So what does this mean for procurement? Theresa May's letter gives some insight into the government's intentions for these negotiations. The United Kingdom wants to agree with the European Union a deep and special partnership that takes in both economic and security cooperation. The United Kingdom does not seek membership of the single market. If, however, we leave the European Union without an agreement, the default position is that we would have to trade on World Trade Organization terms. We know, therefore, that we will not be joining the European Economic Area, the EEA, alongside Norway, Iceland and Liechtenstein. That would have required us to continue our current procurement regime in its current form. The UK's position on procurement will, therefore, be determined by whatever agreement the government achieves in the negotiations, or we will revert to the rules of the World Trade Organization, the WTO, if an agreement cannot be achieved. We will come back to the WTO position later. How will procurement feature in the Brexit negotiations? Procurement was one of the areas targeted by the Leave campaign as an area which could be improved if the UK left the EU. The UK's current procurement regime is derived almost exclusively from EU law. A common criticism is that the system is expensive, time-consuming and unnecessarily bureaucratic. During the referendum, alongside its claims about increased NHS funding, the Leave campaign claimed that £1.6 billion per year and 1.9 million days per year could be saved by amending the procurement rules and cutting through EU red tape. Are these claims and criticisms really justified? Only time will tell whether public procurement will improve when we are outside the EU. But there are a few factors worth noting. Although procurement law is derived from EU directives, it should be remembered that the UK was heavily involved in the development of the EU directive. Parts of the directive were specifically designed to ensure that the EU's procurement rules were compliant with the WTO rules, which we'll come on to later. When the UK came to transpose the EU procurement rules into UK law, they took a gold-plated approach. In other words, the UK didn't simply incorporate the minimum EU procurement standards into UK law. They included additional procedures and requirements. It is also worth looking at the UK's comparative performance in this area against other EU members. According to a report published by the Centre for Business Research in 2013, procurement in the UK is the most expensive in the EU, and procurement in the UK takes an average 53 days longer than the rest of the EU. So perhaps it is not entirely fair to lay all the blame for cost and delay in our current procurement regime on the EU. So what happens next? All we know for sure is that the government is planning on enacting the Grand Repeal Bill to take the UK out of the EU. The government published a white paper last Thursday explaining how this will work in practice. First, the government will be repealing the European Communities Act 1972, which was the legislation which took the UK into what was then the EEC in the first place. The European Communities Act is also the legal basis upon which all EU directives have become part of UK law. Repealing the Act would therefore also repeal the Public Contract Regulations 2015 and all other procurement legislation. However, that is not going to happen because the second part of the Great Repeal Bill is to import into UK domestic law all EU law as it stands at the moment the UK leaves the EU. So in short, the day the UK leaves the EU, procurement law should not change. That is save in one important respect to make any corrections to EU law so that it properly reflects the fact that the UK is no longer in the EU. For example, any references to the European Court of Justice in legislation will need to be changed because that court will no longer have jurisdiction over the UK. In terms of the procurement legislation, there are a considerable number of EU references in the regulations which will need to be considered and adjusted. What the final version of the regulations will look like will largely depend upon the agreement reached with the EU. For example, will UK public authorities still be able to, or be required to, advertise tenders in the official journal of the European Union? Will businesses in other EU member states still be able to bid for UK public contracts and vice versa? And this is where we are very much going into uncharted territory, with some very important policy decisions needed by the UK government. Fairly close to the top of the list is whether the UK can actually meet all its public procurement needs from within the UK. Although in percentage terms the volume of work awarded to non-UK companies is low, there are some areas where overseas skills and expertise are required and valued. Politically, you would expect there to be a fairly strong political and commercial imperative from the EU and the UK to achieve some level of compromise on this. If that does happen, it seems likely that the procurement rules may end up little changed. The government already has scope to simplify procurement rules whilst we are still in the EU, but hasn't. Are they likely to do so after leaving the EU, with everything else they need to focus on? What happens if there is no deal? This is where the WTO rules come into play. The UK is a long-standing member of the WTO in its own name, and is also a member as part of the EU. Although this has been questioned, it seems unlikely the UK would need to apply to rejoin the WTO. WTO rules cover many aspects of international trade, including trade tariffs, which are outside the scope of this talk. Importantly, they also provide a public procurement regime for WTO members, known as the General Procurement Agreement, the GPA. Here the UK is at a disadvantage, because it is not a party to the GPA in its own name, but just as a member of the EU. Also, the GPA does not provide a complete procurement code between WTO countries. Each party to the GPA needs to agree a schedule with the other members listing exactly which areas of their procurement market they will open to the others. Absent an agreed schedule, there are no procurement rights. So effectively we are back to the outcome of the negotiations with the EU. Also, the GPA requires members to comply with certain procurement standards and procedures. True, these are not as complex as the EU procurement regulations. However, one of the objectives of those EU procurement regulations was to be compliant with WTO procurement requirements, so that these markets could be opened. If the UK does want to open its procurement market to WTO members, the scope for changing the current procurement regulations may not be that significant. No doubt things will become clearer over coming months as the EU and the UK's respective positions on the final agreement becomes known. We'll be posting regular updates on this on our website. So what sort of things ought your businesses to be doing now in preparation for Brexit? If your business does sell goods or services to other EU member states, it will be worth considering incorporating a subsidiary somewhere within the EU to continue that work in case the UK is shut out of the EU procurement market. It may be possible for that EU subsidiary to subcontract some or all of that work back to the UK post-Brexit. If you are or will be participating in overseas tenders in the coming 2 years, keep a careful eye on how those tenders are managed and structured. Check very carefully that you are not being discriminated against when your bids are being evaluated. Whilst the UK is still in the EU, you have exactly the same rights to win those contracts and challenge decisions as businesses based overseas. Also, check very carefully the terms and conditions that will govern any contracts you win. Some have suggested that Brexit termination clauses might start being introduced shortly. If so, you'll need to factor in the possibility of the early termination of your contract when preparing your bid. And that brings to an end today's procurement webinar, which we hope you have found useful and interesting. As mentioned at the outset, we'll be broadcasting our annual webinar in the autumn, covering everything you need to know when bringing a procurement challenge. We'll also be publishing regular updates and procurement news on our website and via LinkedIn, paying close attention to Brexit developments. If anyone has any questions on any of the issues discussed this afternoon, please feel free to email us on the email addresses on this slide. Thank you and goodbye.